Could the king or the pardons board insert an addendum into a pardon? The answer is no. Why? Since the Najib saga began, the addendum has been, as Churchill famously said, a riddle wrapped in a mystery inside an enigma. In my opinion, the key reasons are: number one, His Majesty the King is not the board. The king must comply with the board's advice. He cannot act outside it. Under the Constitution, he is, although entitled to preside over it, only a part of the board, and that's it set out in Article 42. The decision of the pardons board is a collective decision. The king cannot make a separate decision different from that of the board. There is no proof that the board collectively endorse the addendum. And number three, pardons cannot be granted in installments. A pardon, because it's a collective decision, is a single decision. Pardons cannot be improved over time in bits and in pieces. Number four, whether the government knew about the addendum is completely irrelevant. Even if the addendum exists, and even if its contents are true, the addendum is wholly unconstitutional, and there are three reasons for this. First, under Article 41, Clause 1 and 10, the board can only reduce or extinguish the original punishment, and the board can either completely remove the punishment called the free pardon under Article 46, Clause 1, or it can remit a pardon. It cannot alter the nature or create a new form of punishment. Even if the addendum is genuine, it would still be unconstitutional. The Constitution limits the pardons board to granting pardons, reprieves, or respites, but does not equate these to what's now been called a house arrest. A partial pardon allows for remission, suspension, or commutation of sentences, but does not permit altering the character or nature of a court-issued punishment. Accepted rules of constitutional interpretation do not at all point to any house arrest orders, and no such precedent, as far as I know, exists. Now, a new Act of Parliament is required for that. Without jurisdiction, as you might know, any exercise of constitutional power is void, and the addendum can therefore be ignored. We need transparency. Think about it. A pardon is a constitutional device allowing interference with the court's sentence. Should not that right be exercised carefully and transparently? If the answer is no, then why have laws? Why have the board? Other considerations are important as well, and they are outlined below in a logical order. The decision to pardon under Article 40, Clause 1A of the Federal Constitution is not the King's unilateral choice, but the collective decision, as I said, of the Pardons Board. The King is obliged under the Constitution to comply with the Board's advice and cannot independently amend or override the Board's recommendation. This principle has been consistently upheld all across the British Commonwealth, emphasizing the constitutional binding nature of formal advice on the monarch. Did the Pardons Board discuss or decide on Najib's alleged house arrest? Well, the minutes of the Pardons Board would help. Transparency demands that this information be made public, as it is neither an official secret nor a matter of national security. The lack of clarity will sometimes fuel unnecessary speculation. Now, on January the 29th, 2024, The Pardons Board met to consider Najib's petition for pardon. However, what the AG recommended or what the Pardons Board advised remains unclear. Najib has claimed there was no government response to an alleged addendum to his pardon. The majority members of the Court of Appeal noted that the AG did not rebut the existence of this addendum, which raises further questions. Now, the government's silence on this issue, of course, deepens the controversy, making it imperative for the government to clarify the AG's opinion and the board's recommendations. The addendum, if it exists, reflects a constitutional exercise of power. Transparency is therefore crucial in such exercises to avoid any perception of opacity or ulterior motive. Prime Minister Anwar Ibrahim, advocating accountable governance, should ensure that the public and the judiciary are not left in the dark. Now, under the 9th clause of Article 42, the Pardons Board must consider the AG's written opinion before advising the king. Did the AG recommend a 50% reduction in Najib's sentence or a 77% reduction of his fine? Or were these decisions solely those of the board? We don't know. On the 6th of January 2025, Senior Federal Counsel Shamsul Bol Hassan revealed that the board, in its 29th January meeting, decided to halve Najib's 12-year term and reduce his fine to 50 million. Why the Anwar government would support such leniency, especially for a convicted former leader, raises questions of political motivations. Initial disclosures about the January Pardons Board meeting lacked confirmation. Reuters itself could not verify the details of Najib's royal pardon, and the fine reduction was only reported by the BBC on the 2nd of February 2024. Such delays in communication induce public mistrust. Now we need to look at some of the constitutional provisions. Article 42, clauses 9, 8, and 41A make it clear that the king is bound to act on the Pardons Board's advice. The king cannot impose his view over the board's decisions. The letter referring to the addendum dated January 4, 2025 surfaced after His Majesty the Sultan of Pahang ended his reign as king. Addressed to Najib's son, the letter and its contents remain unconfirmed, but its timing raises serious questions. Najib claimed that the addendum granted him house arrest, but the Pardons Board's statement on the 2nd of February 2024 made no mention of such an arrangement. The power to pardon rests with the government, exercised in the name of the king. If the addendum was not discussed at the Pardons Board's meeting, any unilateral action by His Majesty the former king would lack jurisdiction. Once a monarch's reign ends, his authority to issue pardons ceases. If the addendum was issued after His Majesty the Sultan of Pahang vacated office, it is legally null and void. Now, governments traditionally grant pardons to individuals who are morally innocent and not to those guilty of corrupt practices. This principle is essential to uphold public confidence in justice. Najib's case, involving significant corruption, cannot reasonably justify a pardon based on moral innocence. Allowing house arrest for a convicted politician sends a dangerous message, undermining efforts to combat corruption. The issues surrounding Najib's pardon highlights questions of transparency and governance. The lack of disclosure about the Pardon Board's decision and the AG's recommendations continue to perpetuate smokes and mirrors effect, obscuring the truth. Political power, when shrouded in opacity, fosters public disillusionment and erodes trust in the constitutional process. Thank you. Goodbye.